Hello, everyone, and welcome to our training about eligibility for the CARE Act. We're going to be talking about what that looks like in practice. Again, thank you for all the feedback that you've been given. If you need any clarification or technical assistance about eligibility, please reach out to us. Also visit our CARE Act website, careact.org, and make sure you're signed up for any training, the listserv, to receive notifications on trainings and to view our past trainings, and let us know if there's anything additional we can help you with. So let's take a look at our two presenters today. We are joined by Mark Avery, who is a board certified psychiatrist and a national leader on the subject of person-centered integrated psychiatric care for high needs patients. So he's going to talk us through some of these eligibility criteria and what that looks like in practice. And we're also joined by Carol Clancy, who is a licensed clinical psychologist with 20 years of leadership experience in correctional health, recovery services, and other public and nonprofit mental health settings. And she's going to be putting the eligibility criteria in the context of the care flow. And so if we just look at the next slide, we have our agenda today. And like I mentioned, the first section will be focusing on those eligibility criteria, and we're going to be looking at another case example to see what that looks like. And then Carol will lead us through what the care process looks like and highlighting the points at which eligibility is documented and determined. So on the next slide, we'll see some of those learning objectives that we're targeting today. So after the end of the session, you should have an increased ability to describe schizophrenia spectrum and other psychotic disorders that are eligible and those that are not eligible on their own. Also list some of those functional impairments related to these disorders and eligibility criteria that qualify for the CARE Act. And then at the end of the session, you should better be able to identify those key inflection points in the CARE Act process in which those eligibility criteria are assessed and applied. And we'll learn more about those in a moment. So I'm going to turn the time over to Mark to kick us off in a discussion about what those eligibility criteria are. Mark?
Hello, everybody. Today's training is in two parts. And in the first part of this training, we'll be discussing a description of the CARE Act eligibility criteria from the clinical perspective. Could I have the next slide, please? So in this training, we're discussing CARE Act eligibility. And we wanted to start off by showing where in the process of the CARE Act program eligibility is assessed. You may be familiar with this CARE process diagram, which flows from left to right through the steps of initiation and engagement, through the court processes, and then the actual CARE Act service delivery phases. Let's click next, please. And here you can see the 6 points in the CARE Act process where engagement might be assessed. We're going to focus on the initial parts during engagement and the court processes for today's training. Let's move to the next slide, please. Today we're discussing eligibility, and we'll be using a vignette to demonstrate the initial petition process for the CARE Act. So let's meet Ming, an imaginary person, and let's hit next, please. Ming is a 42-year-old single woman. Let's pretend she's enrolled at Stanislaus County Behavioral Health, where she has been diagnosed with schizophrenia. She also lives at a board and care home, and lately has been increasingly disappearing from that board and care home for days at a time. Staff there also report that she's mostly stopped taking her antipsychotic medications, and eventually she showed up in San Francisco and was brought to San Francisco General Hospital Zuckerberg Psychiatric Emergency Department, brought there by police who found her to be threatening others in the street and generally appearing to look paranoid and psychotic. The team at the psychiatric emergency room determined that Ming cannot be held on a 5150 involuntary hold, as they felt she was not an imminent threat to herself or others, nor gravely disabled. They thought that because she had a place to live and was willing to return there. Also in the emergency room, she took her antipsychotic medication and stated she would plan to follow up, though frankly, the emergency room staff were skeptical that she would actually do so. When the emergency room staff called the board and care staff, they heard that Ming has been becoming progressively more paranoid to the point of accusing her caregivers of stealing from her and even controlling her thoughts. So the board and care staff would like to refer her to the care program. So let's hit next, please. So is Ming eligible? Ming may be eligible for the CARE Act because of her diagnosis of schizophrenia, which is covered under the CARE Act. But we need to know more about her before we can assess whether she fits the other criteria for eligibility. Let's hit next, please. So let's think about those other criteria. By statute, an individual qualifies for the care process only if all of the following are true, as demonstrated here on the slide. The person must be 18 years of age or older, and the person must be experiencing a severe mental illness as defined by California statute, and have a diagnosis in the disorder class of schizophrenia spectrum and other psychotic disorders, a term and diagnoses that are defined in the most current version of the Diagnostic and Statistical Manual of Mental Disorders, or DSM. We'll cover that in a bit. The additional criteria are the person must not be clinically stabilized with ongoing voluntary treatment, that participation in either a care plan or a care agreement would be the least restrictive alternative necessary for Ming's recovery and stability. And it's likely that the person will benefit from participation in a care plan or care agreement. Finally, at least one of the following must be true. First, the person is unlikely to survive safely in the community without supervision, and the person's condition is substantially deteriorating, or the person is in need of services and supports in order to prevent a relapse or deterioration that would likely result in grave disability or serious harm to self or others. Before we move on, let's look back up at the second bullet point where it says experiencing a severe mental illness and has a diagnosis of schizophrenia spectrum or other psychotic disorder. Note that there are two parts to that sentence: experiencing the severe mental illness and has a diagnosis of schizophrenia or other disorder. Let's look at those two parts one at a time. With the next slide, please. First, let's talk about the definition of serious mental disorder, because that's actually also defined by California statute. For the purpose of this part, serious mental disorder means a mental disorder which is severe in degree and persistent in duration, which may cause behavioral functioning impairment, and which interferes substantially with the primary activities of daily living, or ADLs, and which may result in an inability to maintain stable and independent functioning without treatment, support, and rehabilitation for a long or indefinite period of time. So note in particular, must be severe in degree, must be persistent, and may interfere with activities or functioning. Okay. That's the serious mental disorder part. Let's move on to the diagnosis part with the next slide. This slide lists all of the diagnoses that are eligible for the CARE program. We've received many questions about which diagnoses are eligible and which ones are not. So before we look specifically at those, consider the following. So the schizophrenia spectrum or other psychotic disorders covers a number of diagnoses. Although most diagnoses in the schizophrenia spectrum or other psychotic disorders chapter are covered under the CARE Act, there are a couple notable exceptions. And also note that only diagnoses that are in the schizophrenia spectrum or other psychotic disorders chapters are considered eligible for the CARE Act. So all the other diagnoses in other chapters of the DSM are not diagnoses that are eligible. So let's look at these. So first, there's the schizophrenia spectrum disorders. You can see them there: schizophrenia, schizoaffective, schizophreniform, other specified and unspecified schizophrenia spectrum or psychotic disorders. Those are all eligible conditions. There are other psychotic disorders in that chapter that are technically eligible: brief psychotic disorder, delusional disorder, schizotypal, substance or medication-induced psychotic disorder, and unspecified catatonia. Note that even though these diagnoses technically meet the criteria for eligibility, their clinical components of those diagnoses would not meet the other criteria of CARE Act. So for instance, the brief psychotic disorder by definition only lasts up to a month and wouldn't meet the duration criteria that I've already covered in the discussion so far. Also note that there are a number of diagnoses that do not meet eligibility. Psychotic disorders due to a general medical condition, for instance, catatonia associated with another medical condition, major depression with psychotic features, bipolar disorder with psychotic features, and any other substance-related disorder that's not listed above. Do note, however, that many patients have multiple psychiatric conditions. So patients may have one of these conditions as long as they have another accompanying diagnoses from the two categories to the left that do meet eligibility. And let's move on to the next slide. So, as mentioned above, there are a number of other criteria for eligibility for the CARE Act. And I won't list each of these individually because I've already covered them, but this slide demonstrates the other attributes that Ming has that meet the other eligibility criteria. She has symptoms that are severe in degree. She has functional impairments. She's unable to maintain stable adjustment. And it's likely Ming would benefit from participation in a care plan or care agreement, and the rest of the criteria listed here on the slide. Let's move to the next slide, please. And let's walk through how we apply Ming's personal situation to the criteria as we're applying for the CARE Act program. To do that, I'm going to call in my colleague, Carol Clancy, to help me with a Q&A about how do the criteria apply to this imaginary patient Ming. So Carol, considering the vignette I presented earlier of Ming, is Ming's diagnosis a qualifying diagnosis in the schizophrenia spectrum and other psychotic disorders class?
Yes, it is, because Ming was diagnosed with schizophrenia. That's an eligible diagnosis at the age of 18.
Right. And she is 18 or older as well. Great. Are her symptoms severe and persistent?
Yes, her symptoms have been persistent for the last 10 years whenever she's unmedicated, and her behavior has been erratic.
Good. Does she appear likely to be at risk for not surviving safely in the community?
Yes, as you noted before, she wanders around sometimes throughout the night due to her delusional beliefs about the boarding care owners.
And is her condition deteriorating?
Yes, she has been increasingly paranoid. She's at risk of losing her board and care placement due to the paranoid symptoms, which result in her leaving home for long periods of time without sharing where she's going. So her functioning has deteriorated in the past few months when she's been increasingly paranoid.
And considering the care program, would this be the least restrictive alternative for her to get the services she needs?
Yes, she's in need of services and supports to prevent further deterioration in her level of functioning. And the CARE Act is a less restrictive alternative for her.
Thank you.
Okay. So thank you, Mark. We are now going to go on to the next section. Can we go to the next slide? And now we are going to talk about the process points to apply for review and eligibility. Next slide. So now we're going to go back to the CARE process to see where eligibility is assessed and by whom. Can we go to the next slide? Okay, so the places where it is assessed is here, wherever these orange arrows are. So for prima facie determination, for the court report and the review of the report, the hearing on the merits, and then for the clinical evaluation. It also is assessed here at the end where you can see if they're reappointed to the program, but that is not going to be our focus today. Our focus today is on the engagement and the court process connection. Next slide, please. What we did here is we put, if you see the little boxes where the reports are, because we wanted to go over where and when are reports being provided to the court. So the first report is the petition, which you can see is needed in order to determine the prima facie, is needed to show that she meets that prima facie determination. The second one is the county report. And the third is the clinical evaluation. So we're going to go through in some detail these 3 points where the court is looking at whether or not she meets criteria. Next slide, please. So on this slide, we are highlighting those 3 inflection points: the petition, the county report, and the clinical evaluation. These are all important steps in assessing for eligibility. We're going to go over each of these steps in the next slide, but for now, we wanted to call out specific information about who prepares the report, what it must contain, and where it is presented or considered. There's a lot of information on this slide, and so we will be going through this more in depth on the next slide. We just wanted to note that the petition, the county report, and the clinical evaluation all play a role in establishing eligibility and the standard of evidence that they must be meeting. So we'll start with the petition. The petition, as we can see here, it must contain facts demonstrating that the respondent meets the eligibility criteria for CARE Act. Once it is presented to the court, if it meets the prima facie standard, the court may request a county report. So in this case, Ming did meet criteria, and the Behavioral Health Agency may show supporting evidence. After the prima facie showing, the County Behavioral Health Agency prepares a county report. In this report, the preparer has to determine eligibility, discuss the outcome of any efforts that they have made to engage Ming, and then make recommendations about the results of those efforts. If the court determines that the report supports a prima facie showing, then the court will set an initial hearing on the merits under clear and convincing standard. So in the case example, Ming still meets criteria. She's found unlikely to voluntarily engage in services. For the clinical evaluation, that has to be prepared by a licensed behavioral health professional with the county behavioral health agency after the case management hearing. This must address diagnosis, whether or not, in this case, Ming has a legal capacity to give informed consent for medication. And it is considered it's considered at the clinical evaluation hearing under the clear and convincing standard. So in this case, Ming is evaluated and the judge considers whether Ming continues to be eligible based on this evaluation. Next slide, please. So we have received a number of questions asking about the information that's needed for the initial petition. So we want to review that now in some detail. So the petition has to contain the following information, has to have the name of the respondent, if known, the respondent's address, the petitioner's relationship to the respondent, and any facts that support the petitioner's assertion that the respondent meets care criteria based on the information in section 5972. The petition should also address each of the 6 eligibility factors listed in section 5972, which Mark discussed earlier today. The petition also must have either of the following. You can have an affidavit from a licensed behavioral health professional stating that they have examined the respondent within 60 days of the submission of the petition, or that they've made multiple attempts to examine the respondent without success within 60 days of the petition, and that the licensed behavioral health professional has determined that the respondent meets or has reason to believe the respondent meets the diagnostic criteria for care proceedings. This must be explained with specificity in this report. If the petitioner does not have that, but the petitioner has evidence that the respondent has been detained for a minimum of 2 intensive treatments, with the most recent one being within the previous 60 days. The Act clearly distinguishes the 14-day hold for intensive treatment, or the 5250, from a 5150. So if Ming had had a 5150 and did not go on to a 5250, then that would not qualify under this standard. So in Ming's case, a licensed behavioral health clinician completes her petition. However, what would be the process if the Ming's board and care manager were to complete the referral? The board and care manager may not have access to an assessment completed by the licensed behavioral health clinician. However, the board and care manager or a family member, if they can attest to the 250 hospitalizations in the last 60 days, then Ming can meet criteria. Next slide, please. We've also received questions asking about what happens if a respondent is not in their home county. So let's look at this example. Ming lives in Stanislaus County, but she's being referred to care court from San Francisco County. How does this referral take place across county lines? So in section 5973, we can find that this is permitted. The petition can be filed in the respondent's county of residence. So it is being filed by somebody from San Francisco County, but it can be followed in Stanislaus County. It can also be filed in the county where the respondent is found, and in the county where the respondent is facing criminal or civil proceedings. So depending on the situation of the person, for Ming, it could have been filed either in Stanislaus County or in San Francisco County. However, if the respondent, in this case Ming, is not a resident of the county where the proceedings are initiated, which she's not, unless the county is voluntarily providing its own services under section 5982, the proceedings are to be transferred as soon as reasonably feasible to the county's to the respondent's county of residence if the CARE Act is operative in the respondent's county of residence, and if the respondent consents to the transfer. So in this case, Stanislaus County, the CARE Act Stanislaus County is also one of the first counties. So the CARE Act would be operative also in Stanislaus County. And if Ming is okay with the case being transferred over to Stanislaus County, since that's where she lives, then that would be okay. That would be allowable under this statute. If Ming does not consent to the transfer, even if that's where all of her services are, if she does not consent to the transfer, then the proceedings are to remain in the county where the respondent was found. Next slide, please. Okay, so the court at this point is required to promptly review the petition to determine if the petitioner has made a prima facie showing that the respondent is or may qualify for care services. So if the court determines that Ming meets the criteria based on the prima facie determination, one of two things can occur. If the county behavioral health agency is the petitioner, the court can set the hearing and optionally order a county report. If the petition contains all the information required by the county report, then they may not have to do another one. If someone other than the county behavioral health agency is the petitioner, then the behavioral health agency will investigate and file a county report. If the court determines the respondent does not meet the criteria based on the prima facie determination, the case is dismissed. The failure to include all the elements of the petition required by 5975 may also result in the dismissal of the case because the prima facie showing has not been made. It also is important to note that the way that this is written in the statute is if all of the information required in the petition is not there, the judge may dismiss the case. So what that means, or one interpretation, is that the court is not mandated to dismiss the case for failure to establish that prima facie basis. So it's important to note that in your county, depending on how it's interpreted, the court may be able to just defer that ruling on the petition and advise the petitioner of the deficiencies so that they can get those deficiencies in. This can be helpful because it can avoid an extra burden on the court because it prevents serial filings of multiple petitions if it's interpreted in that way. Next slide, please. Okay, so now we're going on to the county report. So if the court finds that the petitioner has made a prima facie showing that the respondent meets eligibility requirements, the court may order a report under the following circumstances. If the petitioner was other than the county behavioral health agency, if the petitioner was the county behavioral health agency, but the petition didn't include the information that's required in the county report. So it's important to note that a county report is not required when the necessary information is included in the original petition. The county report should contain the following information: a determination as to whether the respondent meets or is likely to meet the criteria for the care process, the outcome of any efforts made to voluntarily engage the respondent prior to the filing of the petition, and any conclusions and recommendations about the respondent's ability to voluntarily engage in services. The county has 14 days to file a report, but can request for an extension for no more than 30 days beyond that. And that would happen. In some cases, it would happen so that the behavioral health agency has more of an opportunity to work with, engage, and enroll the individual in voluntary treatment and services. Next slide, please. So within 5 days of the receipt of this report, the court must take on one of three actions that we can see here. The first one is they can dismiss the case if voluntary engagement has been effective. In order to show that, the respondent must enroll or be likely to enroll in voluntary services. The court can dismiss the case if the court determines that the county report does not support the prima facie showing that Ming meets criteria for CARE Act services. Or the court can set a hearing on the initial appearance on the petition within 14 court days. And at this point, they would appoint counsel for the respondent and order the county to provide notice of the hearing to the petitioner, the respondent, and the appointed counsel, the county behavioral health agency in the county where Ming resides, and if different, the county where the care court proceedings have commenced. So remember, in Ming's case, if she is okay with the case being transferred to Stanislaus, and that is where that hearing would take place. If she does not give consent, then the hearing would take place in San Francisco since they initiated the petition. Next slide, please. Okay, so next step is the initial hearing and the hearing on the merits. If all parties are in agreement, these hearings can occur concurrently at the same time. If not, they would be two separate hearings. So at this initial appearance, the petitioner, in this case, the hospital social worker, and a county behavioral health agency representative must be present. The respondent may waive personal appearance and appear through counsel. The petition may be dismissed if the petitioner is not present. The initial petitioner is relieved, and the director of the county behavioral health agency or their designee becomes the petitioner. And at this point, the court would set a hearing on the merits of the petition. Again, if it had not been agreed to that both of these can happen in the one petition. At the hearing on the merits, which would be set within 10 calendar days of the initial appearance, the court should determine by clear and convincing evidence that the respondent meets the eligibility criteria in section 5977 and should consider evidence in the petition, the county report, and any additional evidence that's presented by the parties. Note again that at the agreement of the petitioner, the respondent, and the court, the initial hearing and the hearing on merits can occur concurrently. Next slide, please. So the next step in the process is the case management hearing, which we won't spend a lot of time on in this training, but the goal of this hearing is to determine if a care agreement can or cannot be reached. If it isn't or is unlikely to be reached, the court will order a clinical evaluation, which is what we'll be talking about next. Next slide, please. Okay, so at this time, the court orders the county behavioral health agency through a licensed professional to conduct a clinical evaluation of Ming. Alternatively, the parties may stipulate to an existing clinical evaluation completed on Ming during the last 30 days. Here's what this evaluation must address: a clinical diagnosis of the respondent, whether the respondent has the legal capacity to give informed consent regarding psychotropic medication, and any other information as ordered by the court or that the licensed behavioral health professional conducting the evaluation determines would help the court to make future informed decisions about the appropriate care and services the respondent should receive. An analysis of the recommended services, programs, housing, medication, and interventions that would support the recovery and the stability of the respondent. It's the last thing that has to be in the clinical evaluation. Next slide, please. Okay. And then we'd have the clinical evaluation review hearing. At this hearing, the court reviews the evaluation and any other evidence from the County Behavioral Health Agency and the respondent. The County Behavioral Health Agency and the respondent may present evidence and call witnesses, including the person who conducted the evaluation. Only the relevant and admissible evidence that fully complies with the rule of evidence may be considered by the court. At the conclusion of the hearing, the court must make one of the following orders. First, the respondent may meet criteria. And so if the court finds, after reviewing the clinical evaluation and any other evidence, that Ming meets criteria, the court will order the Behavioral Health Agency, Ming, her counsel, and supporter to jointly develop a care plan within 14 days. The court will also set a care plan review hearing no later than 14 days after the parties are directed to develop the plan. The other option is that the court would find that Ming does not meet criteria. If the court finds that after reviewing this evaluation, the respondent doesn't meet this criteria, then the case will be dismissed. Next slide, please. So after going through all of that, we'd want to zoom back a minute to position the key inflection points for assessing eligibility throughout the care process, including the petition, the county report, and the clinical evaluation, and the court hearings reviews in which eligibility is determined. So remember that we're looking at the case initiation, engagement, and the court process service connection phases. This is where these three reports, petition, county report, and evaluation and clinical evaluation, are completed and reviewed. Next slide, please. Okay, so at this point, we'd like you to think about this, consider the roles of the petition, the county report, and the clinical evaluation in outlining whether or not a respondent meets eligibility criteria. And to think just about if all of this made things more clear for you, or if you have additional questions about the role of eligibility. Consider each of the roles. The client, the respondent, the petitioner, the behavioral health agency, the courts and counsel, and think about whether or not it's clear what roles the individuals should have. And if not, to ask questions about that so that it is clear for you. Next slide, please.
Thank you, Carol. I'll take it from here. And thanks to both Carol and Mark for that overview about eligibility and how that fits into the Care Act flow. Again, these are the objectives. We hope you're better able to describe the schizophrenia spectrum and those disorders that are care eligible and understand what aren't eligible, and also keep in mind the functional impairments. Since Mark mentioned the diagnosis is not enough, or not enough on their own, and to understand how those other eligibility criteria qualify individuals for Care Act. And then identify, as Carol went over, those key inflection points where eligibility is assessed and applied, including that petition, the county report, and the clinical evaluation. On the next slide, we'll highlight some next steps that you could take to learn more. Again, please visit the website to access trainings on the Care Act and implementation. You can also submit questions or TA requests if you wanted to clarify. And if you are not receiving notifications on trainings, TA, and other engagement opportunities yet, please complete the form to join the listserv, and that can be found on the website as well. And let's just go to the next slide. It features our email address. Please go to our website to see if there are available resources, but don't hesitate to contact us. We don't mind connecting you with those resources or providing additional answers or responding in that format. So thanks again for joining and viewing this training today, and let us know if you have any questions. Thank you.